rebuttal, please let me know. Our first case is Rivas versus Florida. Mr. Offerman.
Good morning. May it please the court. Michael Offerman on behalf of the appellant Jacqueline Rivas. I'd like to reserve 5 minutes of my time for a rebuttal. I'm hoping to address all of the claims that are raised in the briefs, but I'd like to begin with the golden rule violation. During closing argument, the prosecutor said to the jury, well, if that's actually what happened, if you were actually driving down the road and a biker swerved out in front of you and you hit him, consider all the comments she made that night about what happened. If that actually happened to you, that would be what you would say? If that actually happened to you, you wouldn't say, oh, I didn't hit anybody. And the prosecutor goes on for several more sentences to talk about the various things that the jurors, if it was them, would have done differently than my client.
And you'd agree that in this case, because there was no objection imposed, correct?
Correct.
So for us, the analysis, whether or not this is really fundamental error.
That's correct, Your Honor.
So if looking at the fundamental error, you have to look at the whole case, at the whole trial in its totality.
Yes.
Would you agree with that?
Yes.
Because we can't just simply myopically take one thing out and then indicate, oh my gosh, this is problematic.
Correct.
So we have to determine, is it for the whole case, whether or not it rises to the level that would have affected the jury's verdict in
Correct.
this case.
I agree with that. So that is exactly the standard. There was no contemporaneous objection, so I'm arguing that this does amount to fundamental error. I think that it's clearly a golden rule violation, but I submit that it does rise to the level of fundamental error. This was a close case. The defense put on a theory that this was an unavoidable accident. The defense put on an expert to back that up. There was problems with the state's witnesses about what they saw and whether their memories were properly refreshed, whether they contradicted one another. So at the end of the day, if the jury is on the fence about whether or not this was an unavoidable accident or not, but they're asking themselves, well, the prosecutor told me if I would have reacted differently than the way Ms. Rivas reacted, then that means she's guilty. That's a basis for me to convict. And
But let's put it in context. Weren't there also testimony of the witnesses saying that they saw her car swerve in and out, in and out, in and out, and not just from one, but from several eyewitnesses. And then also there was other testimony that indicated that after the accident took place, just her demeanor, her belligerence, her actions, this was not as close case as I think you characterize it to be. There's a whole bunch of evidence presented before the jury. Would you agree with that?
No, I do not agree that it's not a close case. I agree that there was two witnesses. That's Reed and Charles who testified about seeing swerving. I think there's problems with at least Ms. Charles' testimony from a memory standpoint. She didn't talk to anyone until roughly a week or two or a couple weeks prior to the trial. She wasn't in contact with law enforcement immediately after the accident. She had to have her memory refreshed as to which direction she was even traveling, and she said that she was the car immediately behind my client's SUV when we know that completely contradicts Mr. Reed's testimony. So yes, they both did say that they saw my client swerving. There's no dispute about that. Defense counsel below didn't argue that my client was not intoxicated. The issue is, did she cause or contribute to the accident? And again, the state did not put on any evidence, and this goes a little bit to the JOA argument, or the motion for new trial argument, but the state did not put on any evidence about how the collision occurred. The state had these two witnesses. One of them said they vaguely remember seeing a bicyclist right before the accident. The other one says they saw the bicyclist about a minute before the accident. Neither of them saw how the collision occurred. In contrast to that, the only eyewitness to the accident was Ms. Rivas. She testified that as she was driving, an object darted in front of her from the left. As a result of that, she took a sharp turn to the right to try to avoid it. The defense also put on an accident reconstruction expert. His name is Mr. Fisher, and it's confusing because there's two Fishers in this case. There's the William Fisher, who's the accident reconstruction expert, and there's Ronald Fisher, who was the witness memory expert who could not testify. But Mr. Fisher, the reconstruction expert, testified that it was his belief that, in his opinion, based on all the evidence, that this was consistent with the bicyclist coming from the left, my client swerving to the right to try to avoid it. He said it was unavoidable, and he said that the damage both to the bicycle and to my client's bumper was consistent with that the bicycle was hit from the right rear, and my client, that's consistent with my client trying to avoid the object from the left and turning to the right. So yes, my client was belligerent afterwards. There's no doubt about that, and she made some inconsistent statements about initially she saw an object come at her. She thought she hit an animal. At one point she said she didn't think she hit anything, and you can imagine someone who might be in shock, and the state can use that to try to discredit my client's statement. But at the end of the day, it still is a closed case because the state doesn't have any evidence or anyone who could say exactly what happened at the time of the collision. The defense did put on this theory as to how this occurred, and it would have been unavoidable. And again, at the end of the day, if the prosecutor is inviting the jury to convict my client, if these jurors would have reacted differently than my client, and that's exactly why we don't allow golden rule violations.
Well, let's play devil's advocate. You're taking those statements literally to mean that you're the jury. You don't think it was mentioned like what a reasonable person would have done. This is, and I know this is something that the state argues,
yes,
but you have to read the whole closing argument in context. You don't think that that's an appropriate characterization of those statements?
Your Honor, if that actually happened to you, that wouldn't be what you would say. I don't know any other way to say other than you're looking at the jurors, and if that happened to you, that wouldn't be what you would say. You could say this isn't how a reasonable person would react. And some of these statements, you might be able to put in reasonable person in its place. But to say this over and over again, and to specifically argue, if that would have happened to you, that would not have been how you would have reacted, that is a golden rule violation. I submit that's clear cut. The courts do not allow the attorneys to ask the jurors to put themselves in the position of one of the parties. And in particular in this case, I come back to it, if the jurors were on the fence and it was a closed case, maybe it was unavoidable, we don't know, there really weren't any witnesses that saw the collision, but yeah, the prosecutor was right. The way she acted after the accident, that's not the way I would have acted.
Even if we assume that this was a golden rule violation, the way that the question was phrased, you cited a number of cases that address the issue of golden rule violations. Do any of them, has any court ever taken a golden rule violation on its own and held that that is fundamental error?
I didn't cite to a case that stands for that proposition. I can't say.
I didn't find one.
You say if you're saying you didn't find one, I didn't.
I'm asking you, any of these cases you cited?
Let me rephrase that. Yes, Your Honor. I didn't find one. Had I found one that found the golden rule violation in and of itself amounted to fundamental error, I, of course, would have cited to that. So I didn't find one. It doesn't mean there isn't one out there. Whether I expand my search to the entire country, my best guess is that there would be potentially.
Let's keep it in Florida for the time being. We would be the first court in Florida to hold that an unobjected to golden rule violation can constitute fundamental error.
But that may be true, but you would not be the first court to say that prosecutorial misconduct or improper closing arguments can amount to fundamental error such that it reaches to the heart of the case, vitiates the trial, and the defendant should be afforded a new trial.
So if we were to run along that vein in that analysis, you would have to credibly liken those instances of prosecutorial misconduct that rise to the level of fundamental error with a golden rule violation.
No doubt. Yeah, I mean, clearly, that's the standard you have. There are Florida appellate courts that have granted relief for unobjected to prosecutorial comments and closing argument and found fundamental error. And I submit, and the question is, when looking at those comments in the context of the trial, do we think that the comments vitiated the entire trial, reached to the heart of the trial?
I understand the standard. How do you liken the two groups? In other words, how do you make that link between golden rule violation, which is really just set up there in order to make sure that the jury stays in its neutral, detached observer role?
Correct.
All right.
Yes.
How do you make that leap with the other kinds, such as I think Fifth Amendment?
Sure. Comment on the right to remain silent.
Right. How do you liken those two together?
I still think at the end of the day you have to look what possible impact would this have had on the juror's mind, and you have to ask yourself then, is it a close case? And I submit that it is. And if the jurors could have found my client guilty based on what the prosecutor was asking them to find my client guilty for, that they would have reacted differently.
You're basically telling me the fundamental error standard. What I'm asking is why am I putting, potentially you could say that golden rule violation and a Fifth Amendment violation is an apple and an orange. You could construct an argument on that analysis, right? I mean, in the one instance, you are violating a recognized constitutional right. On the other, you're violating a common law rule that says, hey, don't tell jurors to put themselves in anybody else's skin because we want to make sure that they are remaining detached. And my question is, how are we getting the fruit from one barrel over to the other?
Well, I think they all fall into the category of improper closing arguments. I cited to the defreedist.
So you would have us hold all improper comments by a prosecution can be fundamental error?
Can be, certainly. You have to do the analysis to determine whether it is. I guess the opposite would be that there's some types of prosecutorial improper comments that would never be fundamental error. And I submit that
now that's the converse does not necessarily hold. Because you could have error in a prosecutorial comment that could be cured by a curative instruction.
Sure.
If it had been contemporaneously objected to. Why isn't this that kind of
because
problem?
I think this rises, because of the context of the facts of this case, it does rise to the level of fundamental error.
That's kind of tautological. You're telling me it is I find that it falls within fundamental error because I think it falls within the fundamental error standard. What I'm asking is, why couldn't this problem, if indeed we construe this as improper golden rule violation, why couldn't it have been cured with a curative instruction?
Because, and of course you know this, Ron, there are some comments that the bell just can't be unrung. And courts say that you don't have to ask for a
Fifth
curative
Amendment makes sense, right?
Well, and so, again, you seem to be suggesting that a golden rule argument can never rise to that level. So
No, I'm not. What I'm asking you to do is make the link, liken the Fifth Amendment violation and the
Can I
golden
have a
rule.
second? So let me try to answer your question.
Sure.
I want to do it in two ways. Number one, I've cited to the defreedist case in my briefs. Defreedist said, it's the fourth DCA. As far as golden rule arguments are concerned, the lines are clear and bright. Simply put, they are improper. In short, they enjoy no safe harbor in the trial of a criminal case. No doubt Florida courts have found the golden rule arguments are improper. So then the question becomes, can a golden rule argument rise to the level of fundamental error if it's not objected to? And I submit the answer to that question depends on the facts of the case. If my client had admitted that it was her actions that caused this accident, or in a murder case, if you have a video showing the defendant shoot the victim, the improper golden rule argument would not rise to the level of fundamental error because the court would conclude that there's no way that this had any impact on the jury. It did not reach to the heart of the trial. In this case, because it is such a close case, because the state doesn't have any witness to establish how the collision occurred, because the state, they put on Officer Doyle, who was not an accident reconstruction expert. He didn't come to an opinion as far as how this collision occurred. The defense, however, did put on Mr. Fisher, who specifically said this was an unavoidable accident. And so therefore it is a close case, and if this court can envision that a juror found my client guilty because they would have reacted differently than my client did, and that's an improper basis to do so, then it rises to the level of fundamental error. That's the best I can answer your question, Your Honor. Let me quickly move to the witness memory expert. That's Dr. Fisher. And Dr. Fisher is a professor at FIU in psychology, and he reviewed Mr. Reed's statements pre-trial, and he formed the opinion that Mr. Reed did not actually perceive that there was a bicyclist prior to the accident. He said that...
And why would that not be within the province of the jury to make that determination?
I think, so obviously I've cited to this court's decision in Jones. Jones dealt with an identification expert. I think this is similar. There's some differences between a witness memory expert and an identification expert, but I think they're in the same category of experts.
It's actually a little bit different because we've had a lot of cases on identification witnesses, and there's been a lot of studies, a lot of things made. There's not that much of memory.
And I think that goes to the standard. So the standard in Jones is whether the opinion offered by the expert is of such a nature as not to require any special knowledge in order for the jury to reach its conclusion. So that's the question to be asked. So what did Dr. Fisher say? He said that fabricated memory refers to the idea that some of your memory does not come from the actual episode itself. He said, I think it's Mr. Reed's recollection or his perception of what happened just before and at the time of the accident is a construction based on his understanding of what probably happened given his knowledge of how the world works. So he's opined that Mr. Reed's alleged perception that there was a bicyclist there prior to the collision was actually a constructed or a fabricated memory. I submit that the normal or average juror doesn't have any understanding about constructed or fabricated memories. And this is something that it would be helpful for them to properly assess Mr. Reed's conclusion that, and he testified, I think it's page 174, he vaguely remembers seeing the bicyclist right before the collision. He didn't see how the collision occurred, but he vaguely remembers seeing the bicyclist. If Dr. Fisher could give this opinion and the jury could understand, well, maybe he really didn't see that. Maybe in his mind he's come to this conclusion because he's thinking that must be what happened, that there must have been a bicyclist there, but it's not really what he saw, and then an expert can tell them how the mind can cause you to fabricate or construct that memory. Any challenge that the state would have would go to weight, not admissibility. The state could certainly cross-examine Dr. Fisher and bring out whether or not the jury should give credence to his opinion, but at least the jury would have some context in which to consider whether Mr. Reed did in fact see a bicyclist prior to the accident in this case.
Mr. Crawford, excuse me, you're up to 15 minutes.
Thank you.
Use your time as you wish, but I just wanted to give you the heads up.
Thank you. I appreciate that, Your Honor. So I submit that this is an opinion that should have come in, and it would be up to the jury to decide what weight to give to that opinion. But if you apply the standard in the actual question from Jones, is this something that would be in the normal or average juror's understanding of how witness memory works? I submit it's not, and therefore his testimony would be admissible and helpful to the jury.
And before you sit down, and for us, for that aspect of it, we basically review it as an abuse of discretion. You agree with that? All right. Thank you, sir.
And then I'll spend 30 seconds on the JOA argument. We've touched upon it briefly, but at the end of the day, I do submit that the state did not put on evidence to establish how this collision occurred. The defense did put on a reasonable hypothesis of innocence. The only eyewitness was Ms. Rivas. You have the judge himself during the JOA argument saying what evidence was there in this case that the bicycle came from anywhere. That's the state's burden to prove. And I've cited to the Pennington case from the 5th DCA. It involved a DUI manslaughter case involving a motorcycle and an SUV. And the 5th DCA concluded that the state in that case had failed to establish that it wasn't the result of the motorcycle driving negligently, and therefore the state failed to prove that the defendant in that case caused or contributed to the accident. I submit the same conclusion applies in this case. The state's evidence was insufficient, and or when you apply the weight of the evidence test for the motion for new trial, the judge should have granted the motion for new trial in this case. I'll reserve the rest of my time for rebuttal. Thank you.
Thank you.
Mr. Hurley.
May it please the court, Jonathan Hurley, representing appellate, state of Florida in this case. First, addressing the golden rule. The state does not concede that this is a golden rule violation. When you look at the comments made in context and closing, the prosecutor, within his or her right, is trying to assist the jury in drawing a conclusion based on the evidence presented. The evidence in this case that the prosecutor is addressing is the defendant's version of events, and that being that the bicycle came from the left, cut right in front, and there was absolutely nothing that the driver, the defendant, could do, 100% faultless. So that's the theory, and the prosecutor is addressing the credibility of that theory by examining other evidence that was presented, specifically the voluntary statements that were made at the scene pre-arrest, where the defendant immediately says, I didn't do anything. I was just passing by and I saw this bicyclist on the side of the road. Maybe I felt a bump. Maybe it was an animal. These are inconsistent statements made at the scene of the crime of versions what the defendant at that time said happened. Now the defendant comes up with another version at trial, and the prosecutor is simply drawing the jury's attention to how credible is that based on these previous statements. So we're not even saying that this was not intended to in any way inflame the jury at all. It was simply a proper comment on the evidence presented and addressing the credibility of the defendant's.
It's cast in the sense of you wouldn't do this.
It's a generic term. It's a generic term. You.
Okay. So
could the prosecutor have been clear by saying a reasonable person? Considerably, yes. But if you look at the context, if you flip through the couple of pages prior to these statements and so forth, and look at where the prosecutor's going with this argument, it is not being done to sit there and say, imagine you in this situation and trying to inflame the jury.
I have no doubt that there was no intent to violate the golden rule. I think it's a little bit tricky to state that this is sort of a generic you slash reasonable person, just based upon how it was phrased. I've seen examples of where where the you gets thrown around, because that's kind of colloquial talk. It's how people talk, kind of quickhand. I'm not sure that this falls within that category.
Let's just say the state would not say that this is a clear-cut example of golden rule. Yeah. Okay, we'll go there. But even arguably, even assuming, for argument's sake, that we're going to say this is unintentional golden rule, that the state would argue that it's not fundamental error. It did not vitiate the fairness of the trial, of this trial. You had, the evidence, in short, was pretty much, the evidence of causation was pretty much overwhelming. Again, the first two elements, the operation of the vehicle and whether or not the defendant was under the influence, that was pretty much conceded. So this case really boiled down to causation. So I am somewhat tying in a little bit of the JOA. So it's dealing with the causation. And the evidence that was presented here, you had, and it's not causation from a standpoint of point of impact. That's not what we're getting at here. Was there any operation, any lack of care on the part of the defendant's driving, any evidence of lack of care that resulted in the victim's death? Let's look at the evidence. We had eyewitness testimony before the point of impact, as well as after the point of impact. Before the point of impact, we have direct evidence. Before the point of impact, we have Mr. Reed testifying that the victim basically is driving out of control, swerving from in and out of lanes, and so forth. Right after impact, we have Reed testifying to that the vehicle went up onto the grassy, I won't call it the median, but the grassy side between the sidewalk and the street. You have this grassy stretch right there. So he witnesses the vehicle go up into the side to the area right there.
And then here's a pop. Was he the one that said, and he hears this pop, or he's hears?
I think both he and the other eyewitness, Miss Bess Charles, also heard, testified to the pop.
So when you look at the evidence presented, when he was asked a question, did you see the actual point of impact? He said, I did not. However, what he testified to, he saw the events leading up, and then he testified, as you've indicated, and afterwards he happened to see the bicyclist down, and then later on defendant's actions, how she behaved and so forth. So this is something for the jury. Did he really see the actual point of impact? No, but leading up to it and then seeing her going up, hearing the pop, it's just a natural conclusion.
You could infer, it was a reasonable inference. If you see a car swerving all over, then you see the car going up on top of the road, I think it's reasonable to infer that the operation of that vehicle was demonstrating a lack of care. I think if a reasonable person is watching this, I think you could say that in fact is evidence of a lack of care. Another point, we also have physical evidence, by the way. We have physical evidence. She claims that she braked to avoid the bicyclist. We have Officer Doyle said there were no automobile brake tire marks in the area of the road that this occurred. The physical evidence, it was a clear day. There was no evidence of any operational defect in the car. You've got a tire mark. You do have a tire mark that shows at a 45-degree angle starting, I guess, at the grate. I can only assume the grate, they're talking about the storm drain grate on the side of the road going up into the grass. So you have no tire marks in the area of the road where she would have been braking her vehicle, but you do have tire marks starting at the grate going up into the sidewalk, which is consistent with the state's theory. You also, when it comes to, the question came up to golden rule, and whether it's not per se fundamental error, and I cited to a case, Davis versus State, 604 second 794, it talks about whether or not it's fundamental, whether it's per se or not. Regarding issue 2, the memory let me clarify this. The memory expert of Ron Fisher, again, the memory expert, right? It's not identification expert. This is a memory expert. And Mr. Fisher never interviewed we're dealing with Mr. Reed's testimony. That's really what they're trying to undermine by bringing in Mr. Fisher. And he never interviewed Mr. Fisher. He simply looked at the police reports and said, based on the language that Mr. Reed used in the police reports, I can determine that he really didn't see what he claims he saw at the point of impact. Again, Fisher is not addressing Mr. Reed's statements prior to the impact. He concedes that, yes, he was being truthful about that, or he actually saw that.
Well, it's interesting.
And then afterwards he actually saw that, but it was only the point of impact that, based on the language he uses, that he really didn't, even though he believes he saw it, he really didn't see it.
Well, it's interesting, Mr. Hurley. That becomes, it's almost like he's basically testifying. To accept his testimony, basically he is trying to say that an eyewitness's testimony is wrong. That person is, I hate to use the word, like lacks credibility.
Veracity.
And veracity. And when you look at what is within the province of the jury, this is something that we need to evaluate. It's unlike, and that's why I think I made it a point with counsel, witness identification is different. There's a whole bunch of case law. There's a whole bunch of tests and so forth. But this is different. This is simply somebody coming in and saying, this person's not being truthful. Well, does that really aid the jury? The jury.
It's invading the province of the jury. It's inadmissible. This was not an abuse of discretion. This is abuse of discretion we're examining here on a motion eliminated by the state. Okay, so let's take it in that context. Would any reasonable jurist rule the way the trial court ruled? Okay, so that's the context that this court is examining. So number one, it was inadmissible because it invaded the province of the jury. It's asking the jury to say, don't worry about you examining the credibility of this testimony or examining whether or not this witness actually perceived this or not that. Disregard that. I'm telling you, this person did not see that. That's clearly an invasion of the province. That's not outright inadmissible.
And there's a jury instruction that the trial court usually gives about the credibility. You are to weigh the credibility of the jury, of the witnesses, to determine in your ultimate decision.
In addition, Jones is distinct in this case because Jones is dealing with an ID expert, not a memory expert. And in Jones, identification of the defendant was a critical issue in that case. The identification of who hit this bicycle was not at issue in this case at all. The defendant conceded she hit this bicyclist. So we don't have a identification issue like you did in Jones in this case. So Jones is completely distinguishable. Finally, you could even make the case from a standpoint of a harmless error. Was, as I said before, the point of impact even relevant in this case? From the standpoint of identification was conceded. You also had overwhelming evidence as I went through. You had the physical evidence, you had eyewitnesses, you had the credibility of the witness herself, her version of events, which is totally inconsistent with what she said at the scene of the crime. I thought I had an animal. I was just driving by. I didn't hit anybody, and I just saw the bicyclist down on the road, and I pulled over. I mean, when the jury is examining the credibility of those statements and the weight to be given, I mean, I think it's pretty obvious that even comment here was harmless. I think I covered the JOA. If there's any other questions? Thank you, Your Honor.
Thank you.
May it please the court. The state's evidence in this case, and what was just cited to by opposing counsel, is not inconsistent with the hypothesis of innocence that was presented by the defense and the defense accident reconstruction expert.
But if we're going to do that, doesn't that usually go when there's circumstantial? We're not dealing with circumstantial evidence here. We're dealing with direct evidence. Would you agree?
No, I don't, there's no direct evidence of my client's improper actions causing this accident. There's no direct evidence of how the collision occurred. We know the collision occurred, but there was no witness to exactly how the collision occurred. No one knows where the bicyclist was prior or immediately prior to the collision. So the fact that my client was swerving previously, there's no dispute in this case that she was intoxicated.
Mr. Rivas, I thought Mr. Reed made a comment that he saw her swerve and he saw a bicycle. So there was some testimony that before, and then later on what he basically admitted in his cross-examination, he didn't see the point of impact.
Correct. He says, I vaguely remember seeing a man standing next to a bicycle prior to the collision.
Right.
We don't know that that's Mr. Gattinger. We don't know it's hard to fathom. I mean, Ms. Charles said that she saw the bicyclist riding on the bicycle. Everyone seems to think that Mr. Gattinger was actually riding a bike, but yet Mr. Reed's referring to seeing a man standing next to a bicycle that he's never asked to identify was that man actually Mr. Gattinger. So I think there's issues with what he saw prior to the accident. He didn't see the actual collision. The fact that my client may have been swerving previously doesn't establish that she caused the accident in this case. In Pennington, we know that the defendant was intoxicated, and the 5th DCA nevertheless found that it was the motorcyclist's action that caused the accident in that case. So the state says that my client swerved even onto the sidewalk or off the roadway. Well, yes, that's my client said she did that. Something darted at her from the left, and she swerved to the right to avoid it. And again, the damage to both the bicycle and the bumper is consistent with that. The state doesn't even know which direction Mr. Gattinger was going in. The defense argued in closing that he lives south. My client was traveling north. It was almost sunset. He didn't have any lights on his bicycle, so it was likely he was, in fact, traveling in the other direction, and which would also support that Ms. Charles was traveling in the other direction, and that's why she saw the bicycle about a minute before the accident. So all those facts further show, not only for the JOA or motion for new trial argument, but also, let me come back to the Golden Rule violation. I've been arguing that one impact this had was that the jury went back to the jury room and said, if I would have reacted differently than she did, that's a basis for me to convict. But there's even something worse than that. The very last statement, and this is what I'll conclude with, page 700, the last thing the prosecutor said, you wouldn't give all those other versions of the story that the defendant gave if it truly was not your fault. In essence, the prosecutor is saying, do not believe her version, which is the key to the defense case. Do not believe it if you would have acted differently after the accident. So not only does it invite the jury to convict my client if they would have acted differently, it invites the jury to disbelieve my client, which is the key issue in this case. And that's why, no, Golden Rule violations are not per se fundamental, but they can be. And I submit, when you look at the facts of this case, and because it was so close, it's no different than an egregious Fifth Amendment violation. It deprived my client of a fair trial. It allowed the jury to convict for a reason other than her being guilty. And for that reason, she should get a new and fair trial. Thank you.
Thank you. Thank you both.
Thank you.
Our next case this morning is Everett versus Everett.